Well, thank you very much indeed. I'm delighted to be here on two counts. The first count, of course, is to attend this conference, at least for the first part. Sadly, my day job prevents me from staying today and tomorrow, but I can tell you, having looked at the list of topics and speakers, that if I did have the time available, I would be here for all and everything. The second reason, and perhaps less significant, but important to me, is this is a return visit to the Grand Connaught Rooms from just 10 days ago, where in this very place we celebrated 150 years of the Technology and Construction Court, which is one of the courts in which I sit. Well, let's start, if I may, with what I might describe as the conventional, if there is such a thing, class action in the courts of England and Wales. They are covered procedurally by group litigation orders, and quite often so those cases are started in the General King's Bench Division, where the president of that division has to approve the making of a GLO order. And that's important and actually quite useful, because the president will then appoint a managing judge who will be the judge of that litigation all the way through. There are a number of cases that started in the General King's Bench Division, but then in fact are tried by judges of the specialist courts in the Rolls building, which is where I sit. So, for example, the post office case class action was dealt with by Mr. Justice Fraser. The present Brazilian Mariana Dam case, with over 720,000 claimants, is proceeding now in front of Mrs. Justice O'Farrell, both of those judges sitting in the Technology and Construction Court. On the other hand, some time ago now, I dealt with the first VW diesel emission cases, class action, wearing my commercial court hat. And after a substantial preliminary issues trial of some complexity and various interlocutory hearings, that case settled. I can't really say much more about that kind of litigation because there are other class actions under GLOs which are proceeding against other manufacturers, and I'm not going to be the judge in any of those cases, so fresher pairs of eyes will be looking at them. But I think one thing I can say with some degree of certainty and uncontroversially, if you want to know anything about a diesel engine, I'm your man. Now, in that case, the fact that it was a class action hardly ever featured, as opposed to the substantive merits of the case. And in my view, that is exactly how it should be in a class action, if the parties and their lawyers cooperate fully. So questions of trial, of sample cases, general statements of case, along with statements of case and particular claims, were all pretty much agreed. Even the issues for the first trial, which, as I say, was complex, were mostly agreed with a little help and encouragement from me. But defining the issues clearly and correctly at an early stage is hugely important, especially if you're going to have some kind of preliminary issues trial, which might be dispositive, depending on the outcome. Now, of course, the importance of defining the issues correctly applies to all substantial cases, whether they're class actions or not. And it's something which judges in the Technology Court and the Commercial Court constantly emphasize, so that the parties can articulate and must articulate the issues before the first case management conference. And really only when you do that can you make meaningful directions to trial, and indeed have a meaningful and focused trial. It often requires the judges to be proactive, getting to the heart of the case, because it's all a question of perspective. The perspectives of each of the parties, competing as they are against each other, is different from the perspective of the judge, which is why cooperation between the parties and the judge is so important. And that question of the significance of the issues is a real driver for what can often be highly contentious and difficult procedural debates between the parties in class actions. And I give two examples: disclosure and expert evidence. Disclosure with the plethora of electronic documents is now always a challenging process, but it will become unnecessarily challenged if it is not guided by what are understood and agreed, and if necessary, directed to be the real issues in the case. The same is true of expert evidence. I'm sure you're all familiar with the problem of where, even at a late stage in a case, expert reports appear to pass like ships in the night, making different pronouncements and seeking to answer different questions. That shouldn't happen, and it won't happen if the issues are clear from the outset. You shouldn't be ascertaining what the true issues are only when you try to work out what the disclosure should be or what your experts should be talking about. Now, I've had a little experience at an early stage in working with parties to define issues, because I was a judge in Manchester and I had to deal with a large number of individual consumer claims for relief under the Consumer Credit Act, where there was a point being made that there was an obligation on the part of the bank to provide a copy of the underlying credit card agreement, which in those days would have been signed and completed in writing. And if they couldn't provide a copy, then it was said the credit card agreement was unlawful and unenforceable, and anyone who was owing money under the agreement couldn't be forced to pay. And we had many of these cases, hundreds, possibly thousands, overwhelming the local courts around the country, but particularly in the Northwest. This wasn't started as a class action, and it was up to me to gather them together and to try to make some sense of the common issues, which we did, to find solicitors who were acting for not just one but many clients who could group together and become the lead solicitors, and then proactively working with the parties and their lawyers to work out what the key real issues were and have a trial on that with some sample claims, which is what we did. The claim to enforceability happened to be dismissed, and as a result of that, many, if not all, of the claims which were waiting in the wings simply fell away. We had a similar process when dealing with the first wave of PPI litigation, which we had to coordinate with what became the bank's own voluntary review into those contracts. Well, that was all some time ago, but to come to the present, wearing my hat as a chair of the CAT, the Competition Appeal Tribunal, as has been mentioned, I'm doing one case at the moment. I'm not going to say anything specific about it, except in one uncontroversial respect, because that is a matter which is now going to trial in late January of next year. But that case, along with a number of other decisions on certification and the making of CPOs, collective proceedings orders, has led, as you will know, to a spate of decisions in the Court of Appeal, which have provided important guidance to the parties and indeed to the tribunals as to what their powers are and how they should be exercising them. You will know not only of the groundbreaking Supreme Court case of Merrick's, but has been mentioned already today, Gutman and McLaren in 2022, and then Trucks and Evans in July 2023. It's worth reciting what Lord Justice Green said in relation to the Evans case. He said, "The present case was the first coming before the CAT following Merrick's. There are now over 30 collective actions before the CAT with vast total claims. Many of these claims are highly complex, legal and economically, and in the intervening period, the CAT has grappled with a range of novel procedural and legal issues and has instituted and fine-tuned many case management techniques, all with the object of bringing order and control to what otherwise risks the unleashing of litigation leviathans. Now, as it turns out, even that decision itself was not free from complexity, because after it had been handed down, the president of the CAT sent a memorandum to the court questioning whether, in fact, it had jurisdiction to do one of the things which it said it was doing, which was to vary the CPO which had been made provisionally in the CAT and turning it into an opt-out order. There was also the question of the implications of the decision in Packard by the Supreme Court, which post-dated this original judgment in July 2023. The result of that was that the Court of Appeal decided to reissue its decision in Evans to deal with these additional points. In some respects, their decision was varied, though not fundamentally, and you can find what is now the definitive judgment of the Court of Appeal, which has just been released last week on Thursday, the 9th of November. And I think that just does emphasize the complexity of these cases, which are now increasingly forming the significant proportion of cases before the CAT, and how it is still very much a developing jurisdiction. And indeed, I'm a member of a working group comprised of CAT users and others who are looking at the rules as they now stand and the guide as it now stands. And after all, these rules and the guide are the first version of them that there has been. So like many other bodies, it's right that they should be subject to review and change if that is appropriate. Let me just deal with some aspects, and this is of what we've been doing in the CAT, which perhaps touches on some of the themes, but only rather superficially, I'm afraid, that you're going to be dealing with here. The first one is the question of looking at the funding agreement behind the class action to make sure that it is appropriate from the point of view not just of the class representative, but actually the underlying claimants who are being represented. And that's particularly important where an opt-out CPO has been made. And as the President has said, this is really rather like a supervisory jurisdiction. It's a jurisdiction which the CAT can exercise and should exercise effectively of its own motion. Because the fact of the matter is that any fine-tuning to the funding agreement, which might be thought to be important from the point of view of the underlying claimants, is not going to be raised usually by the defendant, who may have no particular interest in that aspect, and it's not necessarily going to be something which the class representative who's proffered the funding agreement is immediately going to be reviewing for the purpose of the CPR hearing. In some cases, before the CPO is actually made, the CAT may want to make changes to the funding agreement. That's happened in a number of cases, and in all of those cases, the changes have been agreed, and then the matter has proceeded. So it's an additional element of the CAT's jurisdiction, which it has to be very aware of. Now, a second question concerns how to deal with possible settlements. Obviously, the CAT has to approve any settlement, which is fine if the case then settles. But if it doesn't, that tribunal can't continue to hear the case, which means a different tribunal has to be introduced at perhaps a relatively late stage. Now, at one time, the thinking was, and it was expressed in the CAT guide, that the original tribunal, once it had got through certifying the case and making a CPO, should, as it were, withdraw, and a new tribunal should come in to manage the case through to trial. And then if a settlement was proposed, the original tribunal would come back in and approve or not approve the settlement, and then again withdraw. Now, there are problems about that, because obviously, if there never was a settlement proposed, you've changed your tribunal, really without any need to do so. And so that approach has really been changed. And the approach we take now is usually the original tribunal will take the case to trial, or a long way to trial. It certainly won't withdraw immediately after the CPO or a case management conference. And if at some point a settlement is preferred, the president can appoint a second tribunal to come in and consider the settlement. They'll have plenty of materials. They'll have all the particular materials that will have been provided with the settlement papers, but they'll also have what's probably a decision on the CPO and the relevant statements of case. If the second tribunal approve, that's fine, it's the end of the case. If they don't, they withdraw, and the original tribunal simply proceeds with the management of the case. It's yet to be worked out whether that's a definitive rule or whether there should be any stopping points further down the line. But that's where we've got to at the moment. Now, thirdly, let me say something about case management of collective proceedings in the CAT, by reference now to what the Court of Appeal have said in a number of cases. The Court of Appeal has emphasized the broad discretion on case management and directions. It said in recent cases, like Trucks and Evans, that they will expect that after the considerable guidance has been given by the Court of Appeal, that hearings on CPOs which take place before the CAT will be shorter than before, decisions will be shorter than before, and appeals should be rare. The Court of Appeal will be astute to ensure that a proposed appeal really does involve a genuine point of law as opposed to a disguised challenge to what are, in the case, in fact, no more than procedural decisions made pursuant to the CAT's broad discretion. And it's worth recalling that that discretion is a feature not just of general case management and directions. It is actually a discretionary power subject to the rules that have been prescribed when it comes to the making of a CPO, or not, or opt-in, or opt-out. Under Rule 79(2), the Court of Appeal has said it's a value judgment by the CAT of a combination of factors under the rubric of all matters it thinks fit. Too much compartmentalization of different factors can obscure the true value of the exercise, which is by an expert body, namely the CAT. In the context of opt-in and opt-out, the Court of Appeal says that approach, that exercise has got to be approached with, and I quote, a healthy dollop of common sense. Well, of course, academic commentators might say that's all terribly unhelpful, because how do you define common sense? Well, I'll let them worry about that particular problem. But I will be interested to see whether the extent of appeals from CPOs does reduce. This is, of course, in the context where we have this rapidly expanding proportion of collective proceedings work. Now, I suppose that a final facet of all of this is the need for cooperation between the parties to collective proceedings, as I have mentioned. And I touched on that above. Now, the Court of Appeal emphasized that also in the recent cases. And I do think that sometimes, in some cases, and I'm not restricting this to collective actions, sometimes there is still a little of the old culture where one party thinks that if it accepts a suggestion from the other side to do something, it's regarded as some kind of sign of weakness. It's absolutely not the way that judges do not look at these things. And so I suppose I should end by simply saying that these themes of cooperation, the use of common sense, trying to ascertain what the real issues of law and fact are, as opposed to the merely theoretical or speculative issues, these are universal themes from a judge's point of view. And I have sat in most jurisdictions in the High Court, as you've heard. Usually when I've done enough damage in one, they shunt me off to another one. And I can tell you these questions arise in all of those jurisdictions, and regardless of the type of work that the court does. What judges want to do, and indeed what they have to do at the end of the day, is manage a case smoothly to a trial where the real issues are ventilated fairly and get on with producing a judgment, as to which that is something that I now have to get back to. So I hope you will forgive me if I can't stay, but the advantage of my departure now is that it allows you to listen to your stellar cast of speakers, all of whom really do know what they're talking about, as opposed to this present speaker. I very much hope you enjoy the conference. Thank you for your patience.